Of course I can explain the difference between a revocable and an irrevocable trust. First, I'll start with their commonalities. Both revocable and irrevocable trust, if drafted properly and funded properly, avoid probate. That's one of the big things and the reasons people use trusts. Revocable trusts are more flexible in that you can be your own trustee, so you manage the assets, and you can be your own beneficiary. So that works out really well for day-to-day operations. And the downside to a revocable trust is it provides zero in asset protection. Many people have the misconception that if I put my assets in a trust, they're automatically and magically protected from all creditors. The answer is it depends on what kind of trust you've set up. 99.9% of estate planning trusts are simply revocable trusts because people want to maintain control over their assets by being their own trustee and their own beneficiary, and they want the flexibility to be able to change the trust if they ever want. So if one of your children pisses you off and you want to cut them out of the will, super simple. You do an amendment to your trust and you say, little Bobby, you're out of here. On the other hand, irrevocable trusts do provide asset protection, again, if they are drafted and funded properly. However, they are more restrictive. You typically need a third-party independent trustee, although often you can use someone who you trust as a team member, like a child or a sibling, so that sometimes isn't a problem. And irrevocable trust technically can't be modified during your life. They can't be revoked, they can't be amended, and they can't be modified. However, good attorneys figure out a way to put what we call a poison pill into the trust. So while I may not be able to modify it during your life, I typically have a way baked into the language where I could drain the trust of the assets, effectively let it die without having any assets, and then set up a new trust with the rules that you want. So it can be done. And then there's another thing called a testamentary power of appointment. And not to get too technical, but that option will allow you in your last will and testament to change the ultimate beneficiaries of your trust, even though you've never amended the trust language during your life. So lots of differences between revocable and irrevocable. A good attorney will be able to sit with you, explain them to you in detail, not just in 2.5 minutes, and figure out which one works better for you. Oftentimes, it's a combination of two trusts, a revocable for your day-to-day operations that doesn't have a lot of money in it, and an irrevocable where we stash all of our good stuff so that if we ever get sued, we can say, Judge, not my money, and you can't give it to my creditor. Hope this helps. Have a great day.